The subject of this blog is settlement agreements. When facing separation and divorce issues, the parties basically have two choices for resolving their conflict. They can choose the easy way and enter into a settlement agreement where the parties resolve the issues for themselves, or they can do things the hard way where the parties go to court and have the judge decide the issues for them. There are two good reasons why the parties should opt for the easy way to resolve their dispute. First, both parties clearly have a financial incentive to enter into a settlement agreement. That process is much less expensive than battling it out in court and letting the judge decide. This is called litigation and typically requires that the attorneys prepare for trial and go to trial. Litigation is very labor intensive and hence very expensive. The biggest legal fees are the result of the parties going to trial, so you want to avoid this option whenever possible. The second reason that you should try to settle your case is the uncertainty of going to trial. There is always a risk involved in going to trial, and depending on the legal issues and the judge, you can invest a great deal of time, energy, and money and have nothing to show for it when the judge renders his or her decision. A large majority of individuals facing divorce opt for the easy way. 85% of all couples going through separation and divorce enter into written settlement agreements. There are many different names for these agreements: legal separation agreements, property settlement agreements, custody support and property agreements, marital settlement agreements. All of these documents are all pretty much the same thing. They are legal contracts that dispose of the issues between the parties. What issues do these settlement agreements address? They address all issues between the parties, and they're intended to be complete settlements. You don't want to have to go through this process multiple times. These agreements cover child custody, visitation, child support, spousal support, health insurance, property division, debt allocation, and all other matters that pertain to your particular case. Can these agreements be changed once they are signed? The general rule is that valid legal and binding contracts cannot be changed unless the parties agree to change them. The exceptions to this rule are provisions that relate to children, such as custody, child support, and visitation. If circumstances change, these matters are always subject to review and modification by the court. The court will always be able to do what is in the best interest of the children if the circumstances warrant it. Watch out for our future blogs that will talk about the different ways that you can reach marital settlement agreements. We hope to see you back soon. Have a great evening. Thank you.